Hi, and welcome to another Straight to the Point episode, this time in partnership with SGVAP, which stands for Singapore Very Young Arbitration Practitioners. I am Vitor Vieira, an attorney at Alston and Bird LLP, New York, and member of International Desk of the Arbitration Channel. Today we are going to discuss enforcing arbitral awards in China and other alternative venues. Joining me in the interviewing activities is Sunita Advani, who is based in Singapore, where she is an arbitral assistant to Mr. Michael Lee of 20 Essex. She is also the founder and chair of SGVUP. How are you, Sunita?
I'm very well, thank you, Vitor. On behalf of SGVAP, I would like to say a special thank you to the Arbitration Channel and Vitor for partnering with us on this very exciting fireside chat with none other than Simon Chapman KC. Simon is the regional head of dispute resolution in Asia at Herbert Smith Freehills, and he is based in Hong Kong. How are you doing, Simon?
I'm really well, thank you. Really good to be talking to you both. Thank you for having me on.
Thank you for joining us, Simon. I'll start by asking a few questions, and then Sunita will ask you another set of questions. At the end, please feel free to add any concluding remarks or additional observations. As my first question, let's say I'm at the very first stage, before the arbitration. I'm negotiating a contract. Does the seat of arbitration and my client's place of incorporation influence in the chances of enforcing a future award against a Chinese company? How so?
I think the short answer is yes, it probably does. I mean, in theory, it shouldn't have much of an influence because China is a signatory to the New York Convention, and the enforcement track record, certainly in mainland China, has improved significantly over the last few years, and you can enforce foreign arbitral awards from numerous different places now without any issue in mainland China. That being said, there is anecdotal evidence, and the statistics seem to suggest that if you have an award that's seated in Hong Kong, from a tribunal seated in Hong Kong, it is slightly easier to enforce that award in the mainland courts. There's no real rhyme or reason why that should be the case, because the enforcement mechanism for a Hong Kong award is really the same as for any other convention award. But as I say, the anecdotal evidence is that a Hong Kong award is easier to enforce in mainland China. So if your counterparty is Chinese, and all other things being equal, you have a complete freedom as to which seat you might choose for your contract. Hong Kong is an obvious choice. And I don't say that only because I'm sat myself in Hong Kong, but that is, as I say, the anecdotal evidence.
I see. And if we move a step forward, the dispute has begun. Can I take measures to ensure that a Chinese company will have assets that I can use to satisfy my credit? And if so, what would be those measures?
Yeah, well, two things immediately spring to mind. I mean, one thing that you would do in any case with any counterparty and any form of arbitration, regardless of where it's seated, is to try and locate assets. And there are a number of different companies out there these days that will help you do that, that will look for assets owned by that particular company in all sorts of overseas jurisdictions, not necessarily only their place of incorporation. Because obviously one of the advantages of arbitration is you can take your award and enforce it against assets in any court of competent jurisdiction anywhere in the world where that jurisdiction is signatory to the New York Convention. So one thing that we often do is look for, where are the assets of this particular counterparty, not only in their home jurisdiction, but more broadly. The other thing that we're often asked to do by clients before commencing an arbitration or at the same time as commencing an arbitration is consider whether you can freeze any of those assets, so hold them in place pending the outcome of your arbitration so that you know that the assets will still be there at the end of the process. Now, the mechanism to get that sort of freezing injunction, as it's often called, will vary from country to country. In lots of places, there's a very high bar, and you will need to show that there is a real risk of dissipation of those assets. So there's a real risk that your counterparty is going to move them out of the jurisdiction. In China, you have to place some kind of security if you're applying to the local courts to freeze assets. And one of the key advantages, again, of arbitration in Hong Kong, I think this is why Hong Kong is nowadays seen as a natural place for arbitration involving Chinese parties, is this new interim measures arrangement between Hong Kong and the mainland. So if you've got an arbitration that's seated in Hong Kong and that is before an arbitral institution, so not an ad hoc arbitration, but for example, an HKIC or an ICC case seated in Hong Kong, you can apply for interim measures through the institution in the PRC courts at the same time that you commence your arbitration. And it's a very frequently used tool, and it can be a very powerful tool, to your point, Vitor, to ensure that at the end of the process, there will still be assets that you can enforce against. And that is something now that's considered routinely in China-related arbitrations, particularly where there's any concern about having assets left at the end of the process to enforce against.
Thank you. Thank you very much. And if, let's say, I have not taken any precautionary measures, I was not well advised by you in that instance, and or it was not available, it was like the assets were in a jurisdiction that was very hard to obtain such measures. Should I consider other venues, alternative venues such as Singapore instead of China? Is there any venue that is common to find assets that would be a good alternative venue to China?
I mean, this is one of the benefits of obtaining one of these reports from a third-party asset search company, or indeed there are often now other third parties involved in the process, such as litigation funders, who will help do this and have a sort of in-house function to go and help you locate assets. You can do that at any point in the process. It's often very wise and good practice to do it before you press the button on an arbitration, so that you can be sure that when you get to the end of the process, there will be something left to enforce against. But as you say, Vitor, if you haven't done that at the start, or even if you have, but you haven't frozen those assets and therefore you want to refresh your search and work out what is still available, you would do it again. You would commission another report at the end of the process. And what we often do then, armed with that knowledge, is list the assets in terms of priority, depending on obviously the size of your judgment, how much money ultimately you need to collect, to say, well, where are the assets that are the most valuable and that are going to be the easiest to enforce against? And where are the jurisdictions that are most favorable in terms of enforcement? So you mentioned Singapore, for example, which has a very positive track record in terms of upholding, recognizing and enforcing arbitration awards with a relatively straightforward system for doing that. So you would look at where the assets are located and work out where is going to be easiest in terms of your enforcement strategy.
Thank you, Simon. How does China's legal framework for enforcement of arbitral awards compare to that of other jurisdictions?
It's very similar in many respects. The criteria that the basic criteria that you would need to enforce an arbitral award and the steps that you will take will be very familiar to the basic process that is in place in many other jurisdictions. You need to make sure that you've got an original copy of the award. You need to make sure that you've got evidence of the underlying arbitration agreement. Obviously, if the award is written in a language other than Chinese, you will need translations to present to the PRC court. The one key difference with the Chinese system, and one actually that's a real selling point and does give certainly foreign parties a degree of comfort in relation to enforcing awards in mainland China is what's called the reporting system. And this only applies to foreign arbitration awards. So a Hong Kong award qualifies as a foreign award for these purposes, even though Hong Kong is part of China because of the one country, two systems mechanism, or a Singapore award, or a London award, or a New York award. If you take that to the mainland courts, and the court at first instance, the enforcing court, decides ultimately that it doesn't want to recognise the award, it's going to refuse recognition for any reason, then the court has to refer that up to the next level of the court and ultimately up to the Supreme People's Court before that decision becomes final and binding. And that system is really important, and it's there to ensure a degree of uniformity of approach, a consistency of approach across the mainland. And from the perspective of the overseas party, it helps to some extent to mitigate the risk of any local protectionism. You know, if you're trying to enforce an award in a province of China where your counterparty is a major employer, for example, it helps mitigate that risk that you will receive unfavorable treatment from the local court, because ultimately it has to be escalated all the way up the chain, potentially to the Supreme People's Court. And that is a difference in terms of the system of enforcement in mainland China as compared to other jurisdictions, but it's actually something that's very favorable and something that, you know, certainly in the years that I've been in Hong Kong has always been seen as a real selling point, actually, of the enforcement regime in mainland China, and something that will give award creditors lots of comfort in the process.
That's really fascinating. So, are there any particular sectors or industries where the enforcement of arbitral awards in China tends to be more challenging or complex for non-Chinese parties? And if so, why?
So again, the answer in theory should be no, because the same system applies to any form, certainly a foreign award. Any form of foreign award is enforced in the same way, regardless of the sector, regardless of the particular industry that you're in, regardless of the subject matter of the award. That being said, you always have to pay particular care in China, just as the same in many other jurisdictions, about certain types of business or investment which are restricted under PRC law. That there are certain types of contract which have to be governed, for example, by PRC law, or which have to provide for onshore arbitration, where you don't have an option to arbitrate your disputes outside of China. And the basic rule on that sort of thing is you have to be able to demonstrate that there's some kind of foreign related element to the dispute or the contract for you to be able to take it outside. Normally that's satisfied by the identity of the parties. If one party is a Singapore company and the other party is a PRC company, then that is a foreign related element. So you have to make sure that you haven't fallen foul of any of those basic rules at the time that your contract was created, because otherwise, of course, then there's going to be a potential argument that your underlying agreement to arbitrate is invalid and you will run into difficulty on enforcement. But other than that, and other than checking that, you know, the particular sector or business area is not in any way restricted under PRC law, there's no reason why an award from a particular industry space or a particular subject matter should be treated in any way differently to any other form of award.
That's really interesting. And what strategies do you recommend for non-Chinese companies looking to enhance their chances of a successful enforcement of an arbitral award in China?
So actually, a number of the things that we've touched upon earlier, I mean, interim relief is a key topic now that comes up all of the time in China-related cases, where you have a foreign party that may ultimately be looking to enforce the award at the end of the process in mainland China, you have to ask yourself, should we be applying for some kind of freezing injunction or other form of interim protection just to safeguard the assets that we know are available, whether that's freezing money in a bank account, or it's freezing some kind of real estate asset, or it's freezing shares in a company so that they can't be traded or sold. All sorts of different alternatives, but that is the most common question now that we are asked at the beginning of any process, is should we be taking some form of step to preserve assets? Now, it doesn't come up in every single case, because there will be obviously cases that are brought against very large, very reputable Chinese companies where you don't need that level of protection. It may also be the case, to touch on the point that Vitor mentioned at the top of the conversation, that there will be assets in other jurisdictions. And that's something also that you should ascertain really at an early stage in the process. Do you have to take this award and enforce it through the courts in mainland China? Or actually, does the company have a bank account in Singapore and you could take your award and enforce it through the Singapore courts instead? Very often in the China context, if you're dealing with a Chinese party, the company structure will involve some offshore element. There will be assets, perhaps shares, perhaps bank accounts in the BVI or in the Cayman Islands. And so you will be looking also at enforcement options potentially through the courts in those offshore jurisdictions. And again, the regime there is very similar to what you would find in Singapore or Hong Kong or London or New York. It's all a very familiar process.
Got it. And our final question is, how do you see the future of enforcement of arbitral awards in China evolving?
I think it already has evolved significantly in the time, certainly that I've been in Hong Kong. I think that that's a testament to the level of investment that there has been in China over that period, just the sheer volume of business that is done between China and other countries, obviously not just in Asia, but globally. I think there's also a degree of reciprocity, because very frequently Chinese companies are investing elsewhere in the world. They are prolific investors in lots of different places. And they will also be looking to enforce their own contractual rights, to bring claims in their own name, and then be looking to enforce arbitral awards in their favor in those overseas jurisdictions. And I think that has been a key driver actually for some of the developments within the mainland. There's that element of reciprocity, that recognizing that Chinese companies and particularly state-owned enterprises will want to proactively enforce their rights and enforce their awards in other jurisdictions has also meant, the converse is also true, that it must then also be easier to enforce awards in the mainland courts. And all of the statistics suggest actually that it is a positive trend towards enforcement in the PRC. I think measures such as the reporting system that I mentioned earlier, that degree of protection that you get if a court wants to refuse enforcement and has to refer it up the chain, does ensure that there is greater uniformity of approach within the PRC. And we've seen also things such as the public policy exception that I know you'll be familiar with, which is a provision of the New York Convention and is often used in some countries as a quite sweeping get out of jail clause to refuse enforcement of awards, actually has been construed relatively narrowly in mainland China and isn't often invoked as a basis to resist enforcement. So my sense is that it's been a positive journey, that the trend is towards easier enforcement through the mainland courts. It's not a perfect system by any means, and I think there are few places in the world that have an absolutely perfect track record, certainly countries the size of China, but it is easier to enforce awards in the mainland than it was perhaps 20 years ago, and I think that the trend very much is a positive one.
Thank you very much, Simon and Sunita. This was very enlightening. Do you have any concluding remarks or additional observations, Simon?
No, I don't think so. I think we've covered a lot of ground over that chat. So thank you very much for your questions. I thought they were great questions, and it's a really important topic and something that we are very often asked about, as you say, at the very start of the arbitration process as well as at the end. So thank you very much for having me on.
Thank you very much for your time and for being here. It was a great pleasure.
Thank you very much as well to Simon and Vitor.
And that concludes our chat.
Thank you both.